Welcome to the Whistleblower Newsroom. I'm Christina Borjesson. The British High Court has recently ruled that WikiLeaks' Julian Assange can be extradited to the United States, saying it trusts the US government's assurances that they will reduce the risk of Assange committing suicide in the American supermax prison to which he would most likely be remanded. Keeping Assange from killing himself would most likely involve drugging him. After being cooped up for 7 years in the Ecuadorian embassy, followed by more than 2 years in the UK's Belmarsh prison, Assange's mental and physical health are fragile. He suffered a stroke last October and has chronic lung problems. A look back at the court proceedings in the UK that resulted in this current extradition ruling raises questions about Assange's survival and the survival of investigative journalism exposing deadly government corruption around the world. But perhaps most troubling of all is the total immunity the plaintiffs fighting Assange have enjoyed as they engineer and carry out a blatantly corrupt process to bring Assange to an American prison cell. Last year, former UK diplomat and member of Assange's justice team, Craig Murray, who witnessed the extradition court proceedings, described them in shocking detail, calling them a charade, a railroad job, scripted by US and UK government security services and carried out by UK District Judge Vanessa Barretzer. As Murray describes it, the railroad job involved flagrantly absurd, if not illegal, decisions and abuse of procedure. Legacy, or mainstream press, has ignored these details, but listen carefully to what Murray has to say. What he's describing is the paving of the way for a fundamental dismantling of an important piece of the world's social fabric by the colluding security/intelligence services of the United States and the United Kingdom. He began the interview by talking about who was and wasn't cherry-picked to witness and report on the court proceedings.
There was a process by which organizations and journalists could present their credentials and get access. And quite a few of them did so and appeared to do so successfully. But on the morning that the hearing started, 42, I think it was, of those organizations had their credentials removed by the judge. And that included Amnesty International, it included Reporters Without Borders, it included quite a few of those, really quite prestigious organizations, PEN, the Organization for Writers Against Censorship. And the judge actually explained, gave a ruling, explained to the court that the access had been removed in the interests of justice, they said. How this was in the interests of justice was never explained, but that was really quite
did she elaborate on that, or did she just say in the interest of justice?
No, she said in the interest of justice. She decided justice would be better served if they didn't have access. Though why, she did not explain. As for journalists, I think mainstream media journalists were able to get video access reasonably freely, and yet they quite simply chose not to use it. It isn't that the Washington Post or the New York Times weren't given video access; they would have had video access.
That's shocking.
But they just didn't cover the trial, in effect.
What is going on with that judge, Vanessa Barretzer? What is going on with her? I mean, is everything she's doing, is the way she's running, she ran that hearing, was that legal? Was all that legal?
My strong impression was that she wasn't really in charge of the trial. I mean, one thing which was noted by many observers was that every time a ruling had to be made, she would come into the court with the ruling ready written. Previously, when hearings have been at Woolwich Crown Court, at Belmarsh, and at Westminster Crown Court, she's come in with them written on paper. at the Old Bailey at the 4-week hearing, she was coming in and reading the judgments off a laptop. But in both cases, the interesting thing is that whatever the point was that was being judged, she was bringing in rulings that had been written before she heard the arguments. Now she knows what's going to be argued, in that both sides have to put in a written argument explaining why they're asking for. So when, for example, the defense asked for an adjournment in order to give them time to prepare a defense against the second superseding indictment, all the new charges that were brought just before the hearing, the defense requested an adjournment, and they had to put in written arguments explaining why they had an adjournment. But then the prosecution put in arguments explaining why they don't think an adjournment should be given. But then there's a process in court where the two argue, and where the defense explained for hours and at length why it was necessary to have an adjournment, going far beyond what they'd put in their written brief. That process of briefing the judge, and then the prosecution replied, and then there's dialogue between the two. All that was ignored. And it's possible, the judgment was prepared on the basis of the written arguments previously submitted, but just ignored, was brought into court before the oral arguments had even been made, before anyone even said anything. So plainly, she wasn't actually listening
well,
to these barristers.
The British courts have something called abuse of procedure. I mean, isn't that a procedure that wasn't followed?
The difficulty is that, and the legal precept of British courts is that the judge is master in her own court. And that's taken as a legal maxim to say that then essentially a judge can do pretty well what they like in their court. So it's
wait a
it's hard
second.
to say. I mean, I asked in fact Gareth Pearce, the very famous lawyer who leads Julian's legal team. I asked her whether it was normal for a judge to write their judgment before they actually hear the arguments, and she said that she there'd been occasions in her career where she's pretty sure it's happened, but normally they at least make some effort to disguise the fact.
Yeah, but you know what I don't understand? I don't understand that the judge is not beholden to the rule of law, to legal process. I mean, yeah, within that, whatever you want to be master of, go ahead. But if you're not following the law, if you're not following legal process, proper legal process in a judicial setting, do you understand? I mean, I get the master bit.
It's difficult to prove, for one thing. I mean, I sat there and I witnessed from my vantage point in the public gallery. I could look down and on the judge's desk, because the public gallery is on a kind of mezzanine level, and I definitely witnessed for sure she didn't alter one word of those judgments as a result of the oral argument she was hearing. And what I was going to go on to say is my personal view, which I can't prove, is I very much doubt she's the person who wrote those judgments that she brought into court. I think she was being given those, but by government or security service influenced sources. She was being told what rulings to make. No, they're not going to get an adjournment. They're not going to have more time to consider the new indictment. Here's your ruling. I don't think she was looking at the written arguments and then writing her ruling, then coming and pretending to hear the oral argument. I think she was being given those judgments to read out. But the whole process is a charade. The whole thing is theatre. There was no genuine legal process happening in front of our eyes at all. It was all a pretensity hearing in which all the judgments on procedural points as we went along, all the major judgments are always on, witnesses and who could be heard and that kind of thing, always went against the defense. Those judgments were made outside that courtroom, and I've got no doubt that the final verdict, was decided before the case started. I had no impression that we were witnessing anything other than a charade throughout the entire.
Well, I mean, I think that's pretty clear. I guess if I were thinking like a member of Julian's justice team, I'd be thinking, what of this charade can I use in the appeal process to show that it was a miscarriage of justice?
And I think there's a huge amount there that can be appealed, including that that refusal to allow an adjournment to give time to respond to the new superseding indictment. The new superseding indictment was received, I think, about 5 weeks before the hearing started, containing entirely new charges, entirely new, about hacking into banks in Iceland and various other matters, which were completely new to the defense, which they'd never heard before. And they only had 5 weeks in which time they didn't have time to gather the evidence and the witnesses, particularly because during that 5 weeks, Julian was being held in Belmarsh jail with almost no access to his lawyers. So how is he meant in that time to prepare a defense to these two charges? So I mean, that's just one of the many points on which an appeal can be made. The legal team are, I think nobody is very hopeful of the decision at this stage of the process because the whole thing seemed like a fit up. And I should say, I'm talking about very experienced, highly regarded senior lawyers who were shocked by the process they were going through, and who weren't used to dealing with this kind of level of injustice and judicial railroading. So that they are fairly confident that once they get to a more senior court, that they would win, that they would win on appeal.
You don't think that there's going to be very heavy pressure from the state apparatus on those senior courts to just ignore?
The state has, and there's a genuine point here, I think, that the state has very limited ability to put pressure on senior courts because, those judges, Judge Borjesson, is a relatively junior judge who wants to be in a senior court. And it's the politicians who have the power who decides to get to be a judge in a senior court, which is done by, it's called the Lord Chancellor's office, but through the Ministry of Justice. Once you get to the High Court or the Supreme Court, you're effectively at the pinnacle of your profession and you can't be removed. And I think you do have, people discover an amount of independence when they become that senior because there's nothing they want anymore. So I think
they're not beholden politically to whoever appointed them, or.
But by and large, no.
Okay. That's hopeful.
It isn't unlike the United States, it's not a party political thing really who gets appointed. Partly because we don't have the social divisions, and there is no significant section of British public opinion which is against abortion, for example. We just don't have those sharp cultural divides that people fall one side or the other of. So it's not really akin to the sort of
Well, I think that's
American
a very hopeful thing. That's a very hopeful thing. I was really so interested in hearing from you directly about the arguments that the lawyers were making about the First Amendment not protecting journalists.
Yeah, no, this was absolutely fascinating. And what was really interesting was after the first week of the hearing, there was a major change in the position of the United States government and the position of prosecution were taking. They started off by arguing that Julian Assange is not a journalist and that therefore he doesn't get First Amendment protection. And they tried to say he's not a journalist because they tried to say he was involved in hacking and he was involved in collusion with Chelsea Manning to obtain the material. We then had a week of very compelling testimony from senior journalists and senior professors of journalism and others who argued that what Julian did in collaborating with Chelsea Manning, for example, was no different at all to what the Washington Post did in collaborating with Deep Throat over Watergate or whatever.
Exactly.
You're a journalist, you cultivate sources. That's what journalists do. And the argument that Julian Assange's behavior was not journalistic behavior, it wasn't running. It
wasn't sticking. They threw that spaghetti on the wall and it didn't stick.
Yeah.
Okay.
So the case was going really rather badly in the first week for the United States government. Then suddenly they called a timeout. Well, what happened was they decided that the husband of the junior lawyer representing the United States government might have COVID. So there was a 2-day break in the trial while her husband and she went off to be tested and everything was reset. And then they came back with a completely new tactic. And after they returned, they argued completely differently. They argued that any journalist is subject to the Espionage Act if they publish classified material. And in fact, mere possession of classified material, whether they publish it or not, makes any journalist subject to the Espionage Act. And they argued specifically, and they said exactly this, in terms. They said that the famous Pentagon Papers New York Times case did not say there could not be a publication and there could not be a prosecution under the Espionage Act. It was only about prior restraint. And they said that in their dicta, a number of the Supreme Court judges in the New York Times Pentagon Papers case stated specifically that there could still be a prosecution under the Espionage Act. So this was a huge claim to make, that any journalist who possesses any classified information,
even a journalist who's not American, right?
Even any journalist anywhere in the world, any journalist anywhere in the world is subject to prosecution under the Espionage Act, and that espionage is not covered by the First Amendment. Now that if the New York Times and the Washington Post and their like were actually paying any attention, that would send immediate red flags up for them. Every journalist in the world ought to be absolutely horrified by this argument, but for some reason it's just not covered. It's quite extraordinary. But that is now the argument that the US government is relying on in this case, that possession of classified material by a journalist is an offense under the Espionage Act, full stop.
I find this very interesting because this not only affects all journalists around the world, but it affects all citizens around the world, because if you look at it as, yes, it's reporting and it's publishing, secret government secrets, but if those government secrets are crimes also, okay, that means the government arrogates to itself total right to classify all of its crimes.
One of the, again, going back to the trial, you're absolutely right. One of the most extraordinary features of the trial was that the judge ruled that there could be no mention in court of possible US government implication in torture, that no evidence could be given of that. So we had Mohammed al-Masri, who was
Yes.
subject to extraordinary rendition, taken to Afghanistan, tortured for 6 months, whatever. His evidence must not include any mention of torture, because she said she was not in a position to judge whether or not torture had taken place. That wasn't the issue before her, so nobody must allege it, she said. And so, we were going through, being taken through WikiLeaks material, being taken through evidences of witnesses who were saying, basically putting the public interest case, saying, explaining what WikiLeaks had revealed and why it was in the public interest that was revealed, but having to do that without mentioning anything to which the United States government might object, like war crimes or torture. And this was an absolutely ludicrous process, because firstly, it meant that things were forbidden from being said which every single person knows are true. I mean, they weren't allowed to say there was torture in Guantanamo Bay. That is just.
You see, to me, that's I don't know. Is that going to be part of the appeal?
Yeah, I think that will be part of the appeal going forward. And also, on many of these issues, as in the El Masri case, for example, the European Court of Human Rights, which is, the highest court, which is above the UK Supreme Court, has already ruled, and had already ruled on the facts of the Masri case. So this very junior court was refusing to accept facts which had been established by courts far, far higher than it. So it made no sense in a legal sense, and certainly in a political sense, and in terms of common sense. People were not permitted to say things that everybody knows are true.
Not only that, but the United States itself, I would say de facto, admitted that WikiLeaks released evidence of crimes because they actually acted on that information to make certain corrections, right?
Yep.
Like with the drone program killing people, they backed off. Is that useful?
Yeah, no, those points were made by the defense, and were made so strongly that WikiLeaks, because one of the key points at issue, of course, is that the US-UK extradition treaty, under which this extradition is taking place, states that specifically there can be no extradition for political offences. And of course, the defense is arguing that the motivation behind the publication was political. Therefore, no extradition can take place, full stop, because it's excluded by the treaty. And one of the prosecution has two arguments. The first argument, which is astonishing to anyone who is not a lawyer, is that aspect of the treaty is not valid because it was not incorporated into British law. There's no UK legislation that says that you can't be extradited for a political offence even though the treaty says you shouldn't be. And that's a strange argument, because obviously the legislation is permissive of what happens in the treaty. It doesn't stop the treaty excluding certain things. It doesn't mean you have to extradite on any grounds whatsoever. And the idea that you're extraditing under a treaty but ignoring some of its clauses,
that's extraordinary.
Is a bit crazy. But the other argument the prosecution make is that the publication was not politically motivated. And here their argument is they say that in international law, the term political can only have the narrow meaning of supporting a political party, and anything that's not done in terms of supporting one party or the other party is not political. So giving the public information in order to try to change policy is not a political act. It's only a political act if you were doing it to support one political party or the other political party. That's the case of the United States government. And again, these are, should the judge rule for extradition on any of these points, these are all appealable points. And some of them are, to a layman, quite crazy. But the lawyers are lawyers, and so they go through and say that in past occasions where there have been international judgments as to what constitutes a political offence or not, it's always been to do with somebody supporting one party or another party. There's no precedent for it meaning anything else. Blah blah. And then produce 80 cases.
Well, there's something very interesting about that statement, though, because what it says is, well, you have the political parties, and then you have the state, and the state answers to no one.
No.
Which is that is essentially, I feel like, the entire thrust of their of all their, if you add all these details together that we've been discussing, they're saying, the state is not Republican, it's not Democrat, it's its own entity, and it has the right to do this. And so what that does, if you think about it, is it completely negates the avenues of power that give the state, the avenues that give the state its power, i.e. the people, the Constitution, the two political parties that fight it out so that, their ideas can, do you understand? So am I making myself clear? It seems to me like they're just basically saying the state is the super entity, and doesn't matter what politics is between this party and that party, and we have nothing to do with it, when actually they do.
Yeah, and I think that's, one thing that's been very plain, I think, throughout, is that it's the security services that are driving this.
Yes.
Anyway.
On both sides, yeah.
On both sides.
Yeah.
And
yeah.
And that the Trump presidency was a break from the norm, in the sense that he wasn't as much of an establishment insider, or as much of the party.
Right.
He was very much part still of the of the ultra wealthy who control everything, but he wasn't part of the political party aspect of that. So it wasn't the background he came from, and it was fairly plain to me that the White House never had any control whatsoever of the security services during Trump's tenure. The security services were doing essentially what they wanted, which to a large extent he found he had to go along with, I think.
They've been in charge of a lot for a long time. That's why, and their power has been accruing, and now it's
and I think what happened with Trump was having somebody from outside the normal political elite come into power made that more obvious than it normally is when it's the Clintons, or dare I say it, the Bidens or whatever,
Right.
who are
Yeah, go ahead and dare, because I think you're right. Yeah.
who've been working within the system for a long while, who are, and we're now going to go back. But I don't think on WikiLeaks we're going to see I'm not anticipating a change in policy coming from the United States.
You also said something very, very interesting, which is at one point they tried to float a deal with Julian that if he would tell them who the DNC leaker was, or hacker, did you not write about that? I remember you.
Yeah, no, but there was a congressman came along who, and the trouble of this is it has deniability. There's nobody denies that the congressman, whose name I forget, Dana Rohrabacher, something like that, came and saw Julian in person, saying he was acting on behalf of Trump, and that if Julian would out the source for the DNC leak, then there could be a pardon, and Julian's problems would be ameliorated. Because obviously it was very much in Trump's political interest to get rid of the whole Russiagate thing, which was always phony anyway. But Julian wasn't prepared to out the source, in any circumstances. So that came to nothing. The line from the Trump camp is that Trump never actually approved that approach. And as I say, it had, if you like, plausible deniability, and we can't prove that was directly from Trump, but it seems very probable that it was indeed from Trump.
Well, it's interesting because Benny was asked to talk to the Trump administration about the findings of the VIPS people, and they said all that was very interesting, and he thought that they were going to follow up on it, and they did not. And it just, you have some you have some information, because you received. Did you receive the thumb drive? Is that correct?
The very strange answer to that is I don't know if I did or not.
Oh, you what? You were given a thumb drive?
I was given a something.
You were given a something which you delivered.
Yep.
To who'd you deliver it to?
No.
Just tell me what you can tell me.
Yeah, I've more or less told you what I can tell you. I was given something and I delivered it. Exactly what it was, I genuinely don't know, which is one reason why I'm quiet on it. I was delivering things in both.
Do you regret not looking?
No, not at all. No. I'm very. I think I'm having been formerly in the diplomatic service.
Yes.
Which is rather a different place to operate. I got used to doing things on a need-to-know basis, if you see what I mean.
Sure.
You need to know your little bit,
right.
And there are very good reasons to organize this so that not too many people know the whole picture. So I was just being a postman, basically.
So that's interesting, because, a lot of people have said, why doesn't Craig Murray, why doesn't he get in touch with people in the Trump administration? Why doesn't he contact the press and tell them, what he knows? And it's because you don't know. It's because you don't know anything. I mean, you are in an interesting position, let's put it that way.
I know a certain amount of stuff I've been told, if you see what I mean, but
yes.
But what I directly witnessed myself was quite limited. But I did offer to tell as much as I know. I wrote to Mr. Mueller saying, I hear you're investigating these matters. I'm very happy to tell you what I know, but I never received any response from him.
So what would you have told him?
What I've just told you, in effect, or maybe slightly more than that. But yeah.
Well, what else? Why are you keeping it from me?
No, I think some things, you know.
All right, let me ask you some questions.
Yeah.
Just are Benny, is the VIPS report, does it track with what you know?
Yeah, and I think Bill Binney's absolutely right. You know, anyone who argues with Bill on what is and what isn't technically feasible and what the technical data shows is crazy. And I think the only thing you really need to know to understand what happened here is the fact that the FBI never ever bothered to look at the DNC servers. You know, if they were serious about finding the truth, then they would have actually investigated the services themselves, not taken the word of CrowdStrike, who were always Party P, and who subsequently, years later, you know, admitted that actually they really didn't have any evidence at all, and in effect made it up. So you know, there's never, the fact Mueller didn't want to talk to me. I mean, there's never been any genuine attempt to discover the truth by the.
Well, the thing is you've got somebody like Ed Batowski, you know, who spent a fortune and as well as his good health to fight what has been an aggressive, well-funded offense against him to shut him up and make him go away. You know, and it's so strange because you also have you have all these bits and pieces. You have your experience and what you have just said. You have who was that Fox analyst who had visited Julian? I forget her name now for some reason. Who was the one who was a friend of Ed Batowski's and told Ed, you know, I spoke to him and he said that the rich boys were involved in this. And, you know, she sort of disappeared. And Julian himself saying, you know, it wasn't a state actor who gave this to me and so on. I mean, these are the things I think that are really troubling in the sense that you've got this extradition hearing, you've got this whole thing going on over here with Ed Batowski and VIPs too, you know, they were subpoenaed for everything they knew. In all of this in a, as I say, an offensive to sort of destroy any information about where that stuff came from, which all goes back to how powerful WikiLeaks and Julian are. You know, what a powerful threat he is. And I just want you to talk a little bit about what you saw in terms of, I mean, do you think they're just trying to kill him slowly without some overt thing because and dragging all of these legal process dragging out? Are they trying to kill him?
I think it would, let me put it this way, I think it would be a very good result for them if he died. One of the most shocking things that came out and was stated quite openly in testimony by a psychologist working, or psychiatrist working for the British government from within the prison psychiatry system, was that they said that in reply to the defense, who were talking about Julian's deteriorating mental condition, he stated that the reason that Julian had been confined to medical wing was not because they accepted his health condition was deteriorating, but because that was the way they could keep him in solitary confinement, which is otherwise illegal in the UK. And the psychiatrist said this because it was his job to say this, that Julian's perfectly healthy and can be extradited. So the defense is saying, well, if he's healthy, why is he confined in the health wing? And you replied, oh, it's nothing to do with his health. It's because that was the only way to keep him in solitary confinement. And that was absolutely astonishing. And the truth of that is borne out by the fact, for example, that the regular health reports, which have to be written by the doctor in charge of a medical ward on anyone who is being kept in isolation in the mental health unit, those reports were never written, for example. So it appears true. And in fact, he gave the reason. He said that when Julian first went into Belmarsh jail, a prisoner took a brief snatch of video of Julian standing by a pool table. And of course, prisoners aren't meant to have mobile phones, let alone take videos. And somehow this video got to the outside world. And that was extremely embarrassing for the jail. And that was why Julian had been put in solitary confinement. But what is, and again, it is just absolutely astonishing that that should be said in court by Dr. Blackwood, the prison psychiatrist who gave this information. But what's undoubtedly true was, as a result of keeping him in solitary confinement, Julian underwent a very severe mental and physical health deterioration during his period in solitary confinement, which was for several months. And I think there was, every reason to be very, very concerned at that stage, because after confinement in the Ecuadorian embassy in a very small space, his health was already not good. Back a year or so ago, a little more, there was reason to be concerned that he might not survive the experience of being jailed, particularly, if they kept him in solitary. I think and the fact, they refused to consider releasing him while COVID was running through the prison system, and Julian has a genuine chronic history of having a weak chest and having coughs and lung problems. I think it would be a very good result for them if he were to die in prison, and I certainly think they've done nothing to avert that. They were extremely aware of the deterioration of his medical condition when they were keeping him in solitary, but they nonetheless kept him in solitary. I think they would have been very happy for him to die at that stage. What we heard in court about the conditions in American supermax prisons were, it was just mind-boggling. It was astonishing. It was almost hard to take it in and believe that people can do that to people. And I certainly think that if he ever got to the United States, it is improbable he would survive that regime.
I'll tell you what really, the hair on the back of my neck went up when I read where you had reported that this Dr. Blackwood had said that they would medicate him enough so that he would not commit suicide.
Yeah, that's right. And the fact you're held for 23 hours a day in a cell that's 9 feet by 6 feet. And if you consider what 9 feet by 6 feet is, that's a tiny, tiny area. And that becomes your world. You're held there for the rest of your life, in effect. And for me, sometimes it's for banal things that bring out the cruelty. And for me, it was Warden Baird, the former prison warden, who'd been in charge of the prison which replicates supermax conditions in New York, where she said that the prisoners were held in a cell that's 9 feet by 6 feet, for 23 hours a day. For 1 hour a day, they're allowed out. And in that period, they're put into another cell, identical, which is also 9 feet by 6 feet. And that's called the recreation cell. And that's their 1 hour.
How can they be out if they're
that's,
in another box?
That's what their 1 hour a day is, in another identical box. That's their
What's the difference? There's no difference?
There is no difference. She said it's exactly the same. It's an identical unit.
That's Orwellian.
It is. She said she tried herself to slightly improve matters by putting an exercise bike in the other cell. So you're in an identical box, but you have an exercise bike for 1 hour a day. But that to me was absolutely astonishing. That you have a recreation cell which is just identical to the one you're locked in, exact same size, and that's your 1 hour a day out. And that's just absolutely astonishing. And of course, anybody would, and you're not allowed to. You have no human communication at all. You're not allowed to talk to anyone. So, of course, people would go
Mad.
absolutely mad. You're bound to go mad.
Yeah, of course.
It's not a survivable situation.
I just want to go back to the court, the trial that's going on in Spain, and its significance to this one, to Julian's extradition or not, and to and to whether or not the courts will hear it in the United States. Because we'll just talk about that, because Dan Ellsberg's experience is very interesting and instructive, because they engaged. The reason why he got off the hook was indeed because the government was engaging in this illegal behavior against him at that time. Yeah,
no, in Dan's case, they burgled his psychiatrist, I know, and did various other acts against him. I mean, in Julian's case, they have, we know from this case in Spain of the Spanish company that was subcontracted to do it, the CIA was spying on his meetings with his legal team, preparing his defense. That, and again, I mean, it's not just the Ellsberg case, that in any genuine court, that fact alone would have the case thrown out.
That's it, yep.
Prosecution has been spying on the defense's meetings with its legal counsel. Any genuine judge would immediately throw the case out. That should be in itself already enough to dismiss the case. And it's astonishing. Also, something that's not been very much publicized is what the defense of the American government to this is. I thought the American government, what I expected the American government to do, is to deny the link with the Spanish company and say it was done through this guy, Adelson, who owns half of Las Vegas, apparently.
Sam, yep.
My expectation was that the defense by the American government would be to say, this is Adelson operating on his own. He's doing it himself, or he's doing it for Trump. He's not connected to the CIA. I thought they would deny any official involvement, but in fact, that's not what they said at all. They've admitted the CIA link and that the CIA was getting this material. And what they're claiming is that Chinese walls, and that's a term they used, Chinese walls within the US government mean that the CIA did not give the material to anyone else. So they didn't give it to the Justice Department or which is simply unbelievable. In which case, what is the purpose of the CIA? Collecting this material and not sharing it with anybody? That would make no sense whatsoever. But the American government is admitting it spied on Julian Assange. It admits it spied on his meetings with its legal team. Its defense is that it didn't pass on that it was this bit of the American government, not that bit of the American government, and we didn't pass on the information to the prosecution, which It's frankly completely unbelievable. It makes no sense whatsoever.
No, it's absurd. It's absurd. And I'm interested in knowing why that is not admissible. That wasn't admissible as a part of the extradition hearing, because if there can be no trial, then why the extradition?
Yeah, well, I mean, the evidence was heard, and was uncontested by the American government. But what the US government, so it has been well, I should say, on the question of what's ruled admissible, the judge heard all evidence on the basis, other than she ruled evidence on torture is inadmissible, but she didn't rule anything as admissible. On the case of everything she heard, she ruled that some of it may be inadmissible, but she'll hear it all. And when she makes her judgment, she will at that point decide what was admissible and what was inadmissible. So some stuff we heard, like about the Spanish case and the CIA spying on Assange's meetings of his legal team, she has heard it. She hasn't yet ruled on whether it's admissible or not. And that will come in her final judgment, where she'll say, I have decided this. I've considered this argument, this argument, this argument. These arguments I didn't consider because I decided the material was inadmissible. And I think that may be one of the ways she finds to justify her decision to extradite, that an awful lot of the most damning material, she will simply say, oh, it wasn't admissible. I couldn't take that into account.
Well, and since she's channeling, clearly it seems like she's channeling the intelligence services, I think she's going to come up with some kind of argument, you know, some kind of argument to justify not allowing that,
Yeah.
that, you know.
To come back to your last point, I should have finished by saying, no, I think for all the reasons we've been discussing, I think the extradition would probably be knocked out by a high court in the UK and not happen. I think a higher court would probably block the extradition. If that does not happen and he is extradited, then I think, again, for the reasons we've been discussing, I don't think this would go all the way through the courts, and it might get a district court in East Virginia to agree to convict, but I don't think it's going to survive appeals to the higher courts in the United States either. But the trouble is, all this could take years. And as you say, the aim is to, obviously the longer Julian's kept in confinement and kept away from being able to be politically active, the better for them. And if they can kill him with prison conditions in the meantime, that's even better for them as well. And you could be talking, by the time we get an appeal done in the UK, you could be talking another 3 years of serious confinement.
Do you think he can take that?
I think it'll be extremely hard. I really do think it'll be extremely hard. I should say, since he's been let out of solitary confinement in the UK and been able to mix with the general prison population, he doesn't look as terrible now as he looked, a few months ago. He does seem to be to give less immediate concern for acute danger of death. Let me put it that way.
Yeah.
He does seem to be a little better, but it's also a question of what does survive it mean? He may physically survive it. Whether he'd be the same person after he came out again is a different.
He can't be. He can't even be the same person right now. I mean, how? So, I mean, we're coming to the close of the show, and I just wanted to ask you. I mean, you're devoting yourself entirely to this team, to Julian's situation, and I just want to ask you, as a former diplomat, as a what do you see? What do you see from all this? What are the things that really strike you?
I worry for kind of loss of hope in a sense. I think 10 years ago, WikiLeaks gave us all huge hope that the internet was going to bring about a new era of freedom of public information where democracy would become meaningful because people would actually know what governments were doing behind the cloak of secrecy, and where also people's ability to interact with each other and to learn news directly without going through the mainstream media. This was all going to have a transformational effect on society. There's been a huge pushback against that. You've got the persecution of WikiLeaks, the persecution of Julian, and you've got the way the internet is developed so that traffic is massively regulated by corporate gatekeepers, Facebook and Twitter.
Social media censored now and openly.
So I view what's happening to Julian as partly, a case of a terrible, terrible injustice happening to a friend of mine on a personal level, but also part of his wider pushback against freedom in society, which 10 years ago seemed to be getting better and now seems to be getting much, much worse. And I think there's a duty on those of us who see that to try to push back against it, which I assume is why you do what you are doing as well.
Well, I mean, I say, and I have said it, many times, where Julian goes, we will all go eventually. And you can see it unfolding right now. So I want to thank you so much for coming on the show. Please give my very best to Julian and his family.
I will do.
And keep going.
We have to.